Yes, Manoj, start. Manoj, are you there?
Yeah. Am I audible?
Yes. But not visible.
Good evening, everybody. I am Manoj Kumar Chaudhary. Welcome you all on behalf of Nani Palkiwala National Law Club. Today we will have a part 4 of comparison of BNSS versus CrPC. I welcome Mr. Jayprakash Somani, Advocate, Supreme Court of India, who has written more than 60 plus books on the different case laws of Supreme Court. He is argued counsel in all type of matter in the Supreme Court. Over to you, sir.
Thank you, Manoj. Friends, this is the last part of BNSS versus CrPC. And in this part, we will complete all these sections. So let me share you the screen first. Just give me a few seconds. Yes. I will take you first up to section 396 something. We completed. Yes. Till section 400 we completed, but we will take again this section 400 and then we'll move further. I have another webinar near about at 6:15. I will try to finish this till 6:15, or I will make little bit late. I will start little bit late that next webinar. No issue. BNSS section 400, order to pay cost in non-cognizable cases. Its earlier section was in CrPC 359. BNSS section 401, order to release on probation of good conduct or after admonition. Its earlier section was in CrPC section 360. BNSS section 402, special reasons to be recorded in certain cases. Its earlier section was in CrPC 361. BNSS section 402, 403, court not to alter judgment. Its earlier section was in CrPC 362. BNSS section 404, copy of judgment to be given to the accused and other persons. Its earlier section was in CrPC 363. BNSS section 405, judgment when to be translated. Its earlier section was in CrPC 364. BNSS section 406, court of session to send copy of finding and sentence to district magistrate. Its earlier section was in CrPC 365. Now friends, we are moving towards chapter 30 of BNSS, Bharatiya Nagrik Suraksha Sanhita. Its earlier chapter was in CrPC chapter 28. Submission of death sentences for confirmation. As you know, when session court is giving death sentence, that time without the confirmation from the High Court, they cannot execute it. So confirmation on death sentence, they have to obtain, session judge have to obtain from High Court. So that provision is now here. BNSS section 407, sentence of death to be submitted by the Court of Session for confirmation. Its earlier section was in CrPC 366. BNSS section 408, power to direct further inquiry to be made or additional evidence to be taken. Its earlier section was in CrPC 367. BNSS section 409, power of High Court to confirm sentence or annual conviction. Its earlier section was in CrPC 368. BNSS section 410, confirmation or new sentence to be signed by two judges. Its earlier section was in CrPC 369. BNSS section 411, procedure in case of difference of opinion. Its earlier section was in CrPC 370. BNSS section 412, procedure in cases submitted to High Court for confirmation. Its earlier section was in CrPC 371. Now, BNSS chapter 31, appeals. Earlier chapter was in CrPC chapter 29, appeals. BNSS section 413, no appeal to lie unless otherwise provided. Its earlier section was in CrPC 372. BNSS section 414, appeal from orders requiring security or refusal to accept or rejecting surety for keeping peace or good behavior. Its earlier section was in CrPC 373. BNSS section 415, appeals from convictions. Its earlier section was in CrPC 374. BNSS section 416, no appeal in certain cases when accused pleads guilty. Its earlier section was in CrPC 375. BNSS section 417, no appeal in petty cases. Its earlier section was in CrPC 376. BNSS section 418, appeal by state government against sentence. Its earlier section was in CrPC 377. BNSS section 419, appeal in case of acquittal. Its earlier section was in CrPC 378. BNSS section 420, appeal against conviction by High Court in certain cases. Its earlier section was in CrPC 379. BNSS section 421, special right of appeal in certain cases. Its earlier section was in CrPC 380. BNSS section 422, appeal to Court of Session how heard. Its earlier section was in CrPC 381. BNSS section 423, petition of appeal. Its earlier section was in CrPC 382. BNSS section 424, procedure when appellant in jail. Its earlier section was in CrPC 383. BNSS section 425, summary dismissal of appeal. Its earlier section was in CrPC 384. BNSS section 426, procedure for hearing appeals not dismissed summarily. Its earlier section was in CrPC 385. BNSS section 427, powers of appellate court. Its earlier section was in CrPC 386. BNSS section 428, judgments of subordinate appellate court. Its earlier section was in CrPC 387. BNSS section 429, order of High Court on appeal to be certified to lower court. Its earlier section was 388. BNSS section 430, suspension of sentence. Just give me 1 minute. I am making silence. Yes, I have done the silence. Switch on the silence mode. Okay. Next, BNSS section 431, arrest of accused in appeal from acquittal. Its earlier section was in CRPC 390. BNSS section 432, appellate court may take further evidence or direct it to be taken. Its earlier section was in CRPC 391. BNSS section 433, procedure where judges of the Court of Appeal are equally divided. Its earlier section was in CRPC 392. BNSS section 434, finality of judgments and orders on appeal. Its earlier section was in CRPC 393. BNSS section 435, abatement of appeals. Its earlier section was in CRPC 394. Now, friends, chapter 32, reference and revision. Its earlier chapter was in CRPC chapter 30, reference and revision. BNSS section 436, reference to High Court. Its earlier section was in CRPC 395. BNSS section 437, disposal of case according to decision of High Court. Its earlier section was in CRPC 396. BNSS section 438, calling for record to exercise power of revision. Its earlier section was in CRPC 397. BNSS section 439, power to order inquiry. Its earlier section was in CRPC 398. BNSS section 440, session judge power of revision. Session judge power of revision. Its earlier section was in CRPC 399. BNSS section 441, power of additional session judge. Its earlier section was in CRPC 400. BNSS section 442, High Court's power of revision. Its earlier section was in CRPC 401. BNSS section 443, power of High Court to withdraw or transfer revision cases. Its earlier section was in CRPC 402. BNSS section 444, option of court to hear parties. Its earlier section was in CRPC 403. Now, one section is deleted from BNSS, which was existed in CRPC at section number 404, statement by Metropolitan Magistrate of grounds of his decision to be considered by High Court, because Metropolitan Magistrate total that post and that complete category is deleted now in BNSS. No Metropolitan Magistrate is there. No Metropolitan cities are now. Earlier it was that Kolkata, Bombay, Chennai, Delhi were metropolitan cities, but now that was deleted. So this section 404 is deleted from BNSS. BNSS section 445, High Court's order to be certified to lower court. Its earlier section was in CRPC 405. Chapter 32 of BNSS, transfer of criminal cases. Its corresponding earlier chapter was in CRPC chapter 31, transfer of criminal cases. BNSS section 446, power of Supreme Court to transfer cases and appeals. Its earlier section was in CRPC 406. BNSS section 447, power of High Court to transfer cases and appeals. Its earlier section was in CRPC 407. BNSS section 448, power of session judge to transfer cases and appeals. Its earlier section was in CRPC 408. BNSS section 449, withdrawal of cases and appeals by session judges. Its earlier section was in CRPC 409. BNSS section 450, withdrawal of cases by judicial magistrates. Its earlier section was in CRPC 410. BNSS section 451, making over or withdrawal of cases by executive magistrates. Its earlier section was in CRPC 411. BNSS section 452, reasons to be recorded. Its earlier section was in CRPC 412. Now, BNSS chapter 34, execution, suspension, remission, commutation means to reduce of sentences. Its earlier chapter was in CrPC, chapter 32, execution, suspension, remission, and commutation of sentences. So after punishment, this part is applicable. So lawyers are getting chance again while accused is now in jail after his conviction, but after some time he can apply for remission or commutation sentence like that. So these provisions are there. So always it is the duty of lawyer to give good relation with the client. Don't neglect their calls. If you are not comfortable to take their call, just tell him, I am busy now, please call me on this time. But after getting money, when lawyer are not giving response, so that a person will ruin his image in the eyes of the clients. So they feel these are the lawyer, selfish lawyer. After getting all fees, now he is not pick up my phone, he is not giving me a proper answer. Always he is speaking with me very angrily. Okay. So such type of things are not happen, friends. If you have a good dialogue, good talk with your client, that time, then for subsequent application, subsequent matter, or your regular client can recommend your name to other persons also in the society. When your behavior pattern as a lawyer, you should be his well-wisher, you should be his guiding friend. Such type of image we should have ourselves in the eyes of our clients. So friends, this chapter 34 of BNSS execution, suspension, remission, and commutation of sentences. Part A, death sentence. BNSS section 453, execution of order passed under section 409. Its earlier section was in CrPC 413. BNSS section 454, execution of sentence of death passed by High Court. Its earlier section was in CrPC 414. BNSS section 455, postponement of execution of sentence of death in case of appeal to Supreme Court. Its earlier section was in CrPC 415. I have handled so many cases of particular these sections, particular this chapter 34 of BNSS. Earlier it was chapter 32. BNSS section 456, commutation of sentence of death on pregnant woman. Its earlier section was in CrPC 416. Part B, imprisonment. BNSS section 457, power to appoint place of imprisonment. Its earlier section was in CrPC 417. BNSS section 458, execution of sentence of imprisonment. Its earlier section was in CrPC 418. BNSS section 459, direction of warrant for execution. Its earlier section was in CrPC 419. BNSS section 460, warrant with whom to be lodged. Its earlier section was in CrPC 420. Part C, levy of fine. BNSS section 461, warrant for levy of fine. Its earlier section was in CrPC 421. BNSS section 462, effect of such warrant. Its earlier section was in CrPC 422. BNSS section 463, warrant for levy of fine issued by a court in any territory to which this Sanhita does not extend. Its earlier section was in CrPC 423. BNSS section 464, suspension of execution of sentence or imprisonments. Its earlier section was in CrPC 424. Part D, general provisions regarding execution. BNSS section 465, who may issue warrant. Its earlier section was in CRPC 425. BNSS section 466, sentence on escaped convict when to take effect. Sentence on escaped convict when to take effect. Its earlier section was in CRPC 426. BNSS section 467, sentence on offender already sentenced for another offense. Its earlier section was in CRPC 427. BNSS section 468, period of detention undergone by accused to be set off against sentence for imprisonment. Its earlier section was in CRPC 428. BNSS section 469, savings. Its earlier section was in CRPC 429. BNSS section 470, return of warrant on execution of sentence. Its earlier section was in CRPC 430. BNSS section 471, money order to be paid convertible as a fine. Its earlier section was in CRPC 431. Chapter E, suspension, remission, and commutation of sentence. A new section is added now in BNSS section 472, mercy petition in death sentence cases. BNSS section 473, power to suspend or remit sentence. Its earlier section was in CRPC 432. BNSS section 474, power to commute sentence. Its earlier section was in CRPC 433. BNSS section 475, restriction on powers of remission or commutation in certain cases. Its earlier section was in CRPC 433A. BNSS section 476, concurrent power of central government in case of death sentences. Its earlier section was in CRPC 434. BNSS section 477, state government to act after concurrent with central government in certain cases. Its earlier section was in CRPC 435. Now BNSS chapter 35, provisions as to bail and bond. Very, very important for trial court lawyer as well as session court lawyer as well as high court lawyer and as well as Supreme Court lawyer. For all lawyers, this chapter is very, very important. BNSS section 478, in what cases bail to be taken. Its earlier section was in CRPC 436. BNSS section 479, maximum period for which under trial prisoner can be detained. Its earlier section was in CRPC 436A. BNSS section 480, when bail may be taken in case of non-bailable offense. Its earlier section was in CRPC 437. BNSS section 481, bail to require accused to appear before next appellate court. Its earlier section was in CRPC 437A. BNSS section 482, direction for grant of bail to person apprehending arrest. That is called anticipatory bail. Its earlier section was in CRPC 438. Anticipatory bail word is not there in CRPC, and that word is not there also in IPC, but it is, we are using it regularly. Anticipatory bail, anticipation of the arrest, that is called apprehension of arrest. So section 482 of CRPC is now. Earlier section was 438, and earlier section was in CRPC 482 is quashing the matter from the High Court. So this difference. I will take one more session, one more short session for the important sections only important section which we are regularly using. So that sections BNSS versus CRPC and BNS versus IPC, like that. So we'll cover that in one webinar, important sections. So section 482 of BNSS, direction for grant of bail a person apprehending arrest. Its earlier section was in CRPC 438. BNSS section 483 special power of High Court or Court of Session regarding bail. Its earlier section was in CRPC 439. BNSS section 484 amount of bond and reduction thereof. Its earlier section was in CRPC 440. BNSS section 485 bond on accused and sureties. Its earlier section was in CRPC 441. BNSS section 486 declaration by sureties. Its earlier section was in CRPC 441A. BNSS section 487 discharge from custody. Its earlier section was in CRPC 442. BNSS section 488 power to order sufficient bail when that first taken is insufficient. Its earlier section was in CRPC 443. BNSS section 489 discharge of sureties. Its earlier section was in CRPC 444. BNSS section 490 deposit instead of recognizes. Its earlier section was in CRPC 445. BNSS section 491 procedure when bond has been forfeited. Its earlier section was in CRPC 446. BNSS section 493 procedure in case of insolvency or death of surety or when a bond is forfeited. Its earlier section was in CRPC 447. BNSS section 494 bond required from child. Its earlier section was in CRPC 448. BNSS section 495 appeal from orders under section 491. Its earlier section was in CRPC 449. BNSS section 496 power to direct levy of account due to certain recognizes. Its earlier section was in CRPC 450. Now BNSS chapter 36 disposal of property. Its earlier chapter was in CRPC chapter 34 disposal of property. BNSS section 497 order for custody and disposal of property pending trial in certain cases. Its earlier section was in CRPC 451. And all these sections are new in BNSS 497.2, 497.3, 497.4, 497.5. BNSS section 498 order for disposal of property at conclusion of trial. Its earlier section was in CRPC 452. BNSS section 499 payment to innocent purchaser of money found on accused. Its earlier section was in CRPC 453. BNSS section 500 appeal against orders under section 498 or section 499. Its earlier section was in CRPC 454. Its earlier section was in CRPC 501 destruction of libelous and other matters. Its earlier section was in CRPC 455. BNSS section 502 power to restore possession of immobile property. Its earlier section was in CRPC 456. BNSS section 503 procedure by police upon seizure of property. Its earlier section was in CRPC 457. BNSS section 504 procedure where no claimant appears without 6 months. Its earlier section was in CRPC 458. BNSS section 505 power to sell perishable property. Its earlier section was in CRPC 459. Chapter 37 of BNSS irregular proceedings. Its earlier chapter was in CRPC chapter 35 irregular proceedings. BNSS section 506 irregularities which do not vitiate proceedings. Its earlier section was in CRPC 460. BNSS section 507 irregularities which vitiate proceedings. Its earlier section was in CRPC 461. BNSS section 508 proceedings in wrong place. Its earlier section was in CRPC 462. BNSS Section 509, non-compliance with provisions of Section 183 or Section 316. Its earlier section was in CrPC 463. BNSS Section 510, effect of omission to fame or absence or error or charge. Its earlier section was in CrPC 464. BNSS Section 511, finding or sentence when reversible by reason of error, omission, or irregularities. Its earlier section was in CrPC 465. BNSS Section 512, defect or error not to make attachment unlawful. Its earlier section was in CrPC 466. Now, friends, we are moving towards chapter 38 of BNSS, limitation for taking cognizance of certain offences. Its earlier chapter was in CrPC chapter 36, limitation for taking cognizance of certain offences. BNSS Section 513, definitions. Its earlier section was in CrPC 467. BNSS Section 514, bar to taking cognizance after lapse of period of limitation. Its earlier section was in CrPC 468. BNSS Section 515, commencement of a period of limitation. Its earlier section was in CrPC 469. BNSS Section 516, exclusion of time in certain cases. Its earlier section was in CrPC 470. BNSS Section 517, exclusion of date on which court is closed. Its earlier section was in CrPC 471. BNSS Section 518, continuing offense. Its earlier section was in CrPC 472. BNSS Section 519, extension of a period of limitation in certain cases. Its earlier section was in CrPC 473. As a lawyer, it is our duty to observe each and every section of this new code and its comparison to older sections of the older code. And always, when you are drafting any matter in trial court, in session court, or in high court, or in Supreme Court, or any agreement like that, or legal notice you are drafting, so don't forget to put both the sections you mention as per the section B of BNS section so and so, and in bracket write older section also. But unless and until people or judges or advocates or industrialists or businessmen, unless and until get used to new law, so our old section we should refer in drafting. That is always better. Now, chapter 39, miscellaneous. This is a last chapter. I think this is last chapter of BNSS. Its earlier chapter was 38 in CrPC, miscellaneous. BNSS Section 520, trial before high courts. Its earlier section was in CrPC 474. BNSS Section 521, delivery to commanding officers of a person liable to be tried by court martial. Its earlier section was in CrPC 475. BNSS Section 522, forms. Its earlier section was in CrPC 476. BNSS Section 523, power of High Court to take rules. Its earlier section was 477. BNSS Section 524, power to alter function allocated to execute magistrate in certain cases. Its earlier section was in CrPC 478. BNSS Section 525, cases in which judge or magistrate is personally interested. Its earlier section was in CrPC 479. BNSS Section 526, practicing advocate not to sit as a magistrate in certain courts. Its earlier section was in CrPC 480. BNSS Section 527, public servant concerned in a sale not to purchase or bid for property. Its earlier section was in CrPC 481. BNSS Section 528, saving of inherent powers of High Court. Its earlier section was in CrPC 482, which already I have mentioned earlier, 482. inherent power of high courts. Such type of inherent power is given to the Supreme Court in so many articles of the Constitution, specifically Article 142 and Article 136. They have a special power. So, sir, such type of special power High Court have also under this section 482. So, quashing of FIR, quashing of criminal cases, such type of matters are always challenged in 482. But now its corresponding section is in BNSS 528. 528. Don't forget. BNSS section 529, a duty of High Court to exercise a continuous superintendence over courts. Its earlier section was in CrPC 483. Such type of superintendency is not mentioned anywhere for the Supreme Court. Supreme Court is a superior than High Court, but control of Supreme Court is not on High Courts. Remember that thing. Because High Court are also constitutional courts, Supreme Court is also constitutional courts. And regarding the financial matters, the payment of High Court judges is always done by the state governments, and the payment of the Supreme Court judges are always given by the central government. So their charging points are different. So nobody is there. So no control of the Supreme Court or the High Courts. But direction, they are giving the order against the High Court orders. They can give the direction to the High Court, but whether to implement or not to implement, that freedom High Court judges always have. But duty of High Court to exercise continuous superintendence over the courts. Over the courts means over the lower courts of that particular state. Suppose Bombay High Court. So Bombay High Court have the power and duty of superintendence of all the district and session courts and judicial magistrate courts, all courts in criminal line, and in civil line, civil courts. Two sections now are balanced only. BNSS section 530, trial and proceedings to be held in electronic mode. This is a new section in BNSS. Trial and proceedings to be held in electronic mode. This is now law. We are enjoying this. We are enjoying this in Supreme Court, in some high courts, virtual hearings, but in district court, in tehsil court, electronic mode is not properly they are operating. But very soon they have to adopt the, and from the, I think, statement, specifically 164 statement, so they can record of any accused person, okay, any accused person from jail also by using the electronic mode. So serious offenses accused, to bring them to the court, so it is very costly sometimes. So much police power required at that time. So specifically terrorist, anti-national movements, accused persons, such type of heavy negative reported persons when arrested. So presenting them before the magistrate court or presenting before them to session court is very costly affair to the state. But now, due to this section, that cost can be reduced now. Drastically, it can be reduced. So last section of BNSS, section 531, repeal and savings. Its earlier section was in CrPC 484. Friends, this is the end of our last part 4 of comparative study of sections BNSS versus CrPC. I will tell Pooja, my PA, to accommodate all this part 4 in one, also in one episode. Okay, so people will get 4 different episodes also on YouTube, and one combine also. Okay, 1 to 4 parts. Similarly, BNSS versus BNS versus IPC. I think we covered that in 3 parts. So there a comparative part should be there. So this is the from my side. Now, as usual, some practical tips for advocacy. Okay. So last time we already discussed how property matters we have to handle in trial court as well as session court. Sorry, not session court, trial court as well as senior division court, district courts, then high court, and then Supreme Court. What is the difference between regular civil matter and what is the exactly property matter? And a person, an advocate, any advocate or any lawyer who is used to property matter is always considered a talented and extraordinary lawyer in the society. Always remember. So handling property matter, specifically succession matter, is very important. We discussed all these points at the end of the last episode. Now, we are discussing here a different mode, that is writ petition. Writ petition in Supreme Court and writ petition in High Courts. Okay, specifically we'll discuss this. So, High Court have a more power in writ petitions. As per the Constitution of India, Article 226 and 227, two articles are there. One is covering their fundamental rights and one is covering their legal rights also. So, always go in writ petition in High Court instead of coming directly to Supreme Court. If extraordinary matter is there, if habeas corpus like that matters, extraordinary matter happens, and extraordinary national importance matter happens, that time you can approach to Supreme Court directly, but Supreme Court is reluctant to admit any writ petition matter directly under Article 32. Because under Article 30, only one article is there for Supreme Court. But there is clear-cut statement in Constitution Assembly by Dr. B.R. Ambedkar, Dr. Babasaheb Ambedkar's statement is that Supreme Court is the custodian of the fundamental right. When nobody is there, nobody is hearing the voice of the downtrodden people, affected people, Supreme Court will. So it is regular practice in Supreme Court. Supreme Court can admit writ petition by only letter also sometimes. There are so many examples, so many leading cases are also there of Supreme Court. One few persons from the jail, they wrote one letter to Supreme Court, and that letter Supreme Court converted into PIL, public interest litigation. And one very, very landmark judgment they have given. So these have the discretion power. These have the discretion power of the Supreme Court to the Supreme Court. So before coming to Supreme Court under Article 32, it is always better to file a writ petition in High Court first. Whenever we find any writ petition directly in Supreme Court, in admission hearing, Supreme Court asks us why you have not approached to High Court, why you come here directly. If our answer is not satisfactory to the bench, they are giving direction, go to High Court first. Then we have to withdraw that petition. Then we have to move to the High Court. So it is better to go High Court first. High Court have two articles for writ petition. Article 226, 227, go through that article, Constitution of India, and act accordingly. And after getting disposed matter by High Court in writ petition, then that order you can challenge in Supreme Court under Article 134, 132, 133, 134, if certification is given by the High Court for appeal to Supreme Court. And if that certification is not given by the Supreme Court, by the High Court, that time under Article 136, special leave petition can be filed directly in Supreme Court against any order, any judicial or quasi-judicial order. What is the wording of Article 136 specifically? Against any judicial or quasi-judicial order, any, not only High Court, district courts or tehsil courts order also you can challenge directly to Supreme Court as per articles meaning. But practically they are not handling. They will not accept direct Tehsil court order direct to Supreme Court. They will tell you proper when existing remedy is available, you should exhaust that remedy. That was important. So go by procedure. Go to appellate court, go to high court, then come to Supreme Court. But if some reason is there, some reluctancy is there, when you are not confident to get the justice from the high court, then in some circumstances are there. That time you explain that circumstances and then directly come to Supreme Court. Or directly come again then in Article 136 to Supreme Court. So that is always better. So that special power Article 136 have, but a writ petition power to Supreme Court is under 32. And there are two categories of writ petition under Article 32. One is regular writ petition and another is public interest litigation. Public interest litigation is connected to a specific 7 to 8 categories have given in Supreme Court procedure. If you want to learn Supreme Court procedure in depth, you can watch my one webinar which I had taken I think 2 years back for the AOR examination candidates. I have taken that 2 hours webinar and already that webinar is available on my YouTube channel. You can refer that, you can go through that, so you can get the ideas of the practice and procedure of Supreme Court. And in that last part of the practice and procedure, they have given 7 to 8 categories of public interest litigation. If that falls in it, and the format is given in the Supreme Court procedure. But before going in writ petition under Article 32, you should exhaust your existing remedies. Generally, writ petition is against government. Generally, writ petition is against government. So against government, when you are putting in a writ petition, so first it is your duty to give representation to the government first. Against which department you are filing writ petition, give your representation in detail properly to particularly for that department. And when that department is not paying attention to your representation, that time you can come to Supreme Court or come to High Court for under writ petitions. जब तक पापा नाम नहीं बोलते आपको, तब तक आप मामा के पास नहीं जा सकते. वैसा same that unless and until department against whom you are moving to the High Court, first give charge to that department to resolve your dispute. Give your representation properly, mention each and everything, because same representation you can put in your writ petition by doing some alterations, some annexures, some more information you can add up later on. But try to cover all the points in representation. But don't write representation through any advocates. Representation to department should be in very polite and very simplified language, so that department should get motivation to resolve your matter. Many times department will resolve that matter. No need to go approach to you. So don't write representation through any lawyer. Tell your client, write representation through yourself in polite and best manner, so that particular department, their soul get charged and they may act in your favor, and the chance to go in court maybe you can avoid it. Okay, so this is today. This is sufficient today for our this part. Now I will ask Manoj to unmute and say, conclude this session. Manoj, are you there?
Yeah, sir. Thank you very much, sir. Such a great advice for the advocacy at the end, which is a very useful for us. And we have covered the BNS and now we have covered the BNSS. So we are waiting for the Indian Evidence Act comparisons. Thank you very much. The participants will let you know when we'll start the Indian Evidence Act comparison with the Sakshya Act, Bharatiya Sakshya Act.
Yes, sure. Okay. Thank you, participant. Thank you.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ. जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं जो Amazon और फ्लिपकार्ट पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।